Australian media outlets can now be held liable for defamatory comments on their Facebook pages. The High Court has upheld a ruling rejecting appeals by some of the country's biggest media companies. The media outlets had appealed against a defamation case that was filed by Dylan Voller, whose mistreatment at a youth detention centre led to a royal commission. But in a majority judgment, the High Court found that creating a post and facilitating comments amounts to participation in the communication of defamatory material. That's even if the creator of the post wasn't aware of comments made later.
And Dr. Nasya Bahfen from La Trobe University in Melbourne joins us now. Dr. Bahfen, quite the landmark ruling there. How much of an impact do you think this will have on media companies, both in Australia and beyond? I mean, are they just going to be shutting the comments function now?
I think the impact of this is going to be quite significant. So the background to it is that media regulation in Australia has largely been seen to work on a very problematic basis, because the media watchdogs here are seen as toothless tigers. So there's not much that the Press Council of Australia or the Australian, the Communications and Media Authority can actually do in terms of regulating the operations of the media. They're seen as toothless tigers, and the media has pretty much been left to regulate itself. Now, what this ruling does in the cases, similar to the one that the High Court ruled on today, what this ruling means is that the media organisations are responsible for those, for the comments that are posted on the Facebook pages that they maintain. So that's a significant outlay, because that'll be a budgetary outlay. There's labour costs involved with somebody having to monitor, constantly, 24 hours a day, somebody having to moderate comments. Otherwise, it will open up people like Dylan in this particular incident. It will encourage people to go the defamation route, simply because the regulatory framework is not there. The media in Australia does tend to regulate itself. And so what a ruling like this means is, if a media outlet doesn't expend the labour costs to have somebody moderate the comments on its Facebook page, it leaves it open to a defamation lawsuit, which can be costly. So I think the impact of the ruling is very significant.
Dr. Bahfen, what might some of the wider implications for the region be on this? I mean, could we expect perhaps other countries to follow suit, to tackle the toothless tiger regulation that you mentioned there?
I think this may not have as much of an impact, certainly on some of Australia's neighbours, where, the pandemic and a couple of other issues have caused those budgets to be even tighter. Certainly in one of our closest neighbours, in Indonesia, there's a lot of issues there in terms of coming to terms with, a functioning democracy. We have to bear in mind that the belief in free speech in Australia that exists and that has led to this notion of the media regulating itself, that's not as established in some of our neighbours. So certainly places like East Timor and in Indonesia, I don't think the level of public discourse around what the media's responsibilities are is at the stage that it is in Australia. There's also, of course, the question of budgets. In this instance, a ruling like this in a legal system like Australia's basically puts the onus then on the media companies themselves. And I don't think that somewhere where the rule of law might not be as established as, say, in Australia or Singapore or New Zealand, within that sort of context, I don't think they'll be looking at things like this, where the majority of the populace might not be in a position to combat more powerful sort of media companies. So I think there's a little bit of difference between Australia and some of its neighbours.
What about the social media outlets, the likes of Facebook, Instagram and YouTube? Does this absolve them of responsibility?
I think what the ruling does, in a way, it does kind of absolve them of the responsibility, because, as a lot of people have pointed out, the media companies and the social media companies, they act as if they are competitors. And certainly earlier this year, when Facebook had a spat with the Australian government, where the Australian government was trying to enforce a media code that would require Facebook to pay for the content that it uses. And they've certainly had a problematic relationship with both the Australian government and with the media companies themselves. But this impact, the impact of this ruling on the social media companies is that it would be seen to support the contention of Facebook and Google that they're not publishers and they're not responsible. They're simply distributors of information. So they would see this as a victory because it endorses their stand that they pushed earlier in the year when they were when the Australian government tried to make those companies pay for content that it was using from the media companies. Facebook's response was, well, we're not publishers. We don't publish this content. We simply draw clicks, to you guys, to the media companies. And so this ruling, it almost vindicates them. So they would be incredibly happy about this ruling.
Good to hear your insights. Thanks very much for your time. Dr. Nasya Bahfen from La Trobe University in Melbourne.